Okay, maybe I'll kick things off here then for Stephanie. So Stephanie is our presenter today, and I am so proud to introduce Stephanie Towery. If you haven't met Stephanie yet, Stephanie is our copyright officer within the university libraries. And she is not only incredibly knowledgeable, but she is very approachable and a absolute wonderful person to work with. And I really do like her a lot. She is talking today about copyright and licensing. So we mentioned a second ago before the recording, please ask questions. Stephanie is very open to asking at the time of the need rather than having to wait to the end. So please do so. You can basically raise your hand, type something in chat, or if there's an opportunity, you can break in as well. So with all that, Stephanie, take it away.
Thank you, Anthony. Let me go ahead and share my screen. There we go. Okay, awesome. So like Anthony said, I'm Stephanie Towery, and I am the copyright officer here at in university libraries. And I am responsible for copyright education, for any kind of specific questions that you have about copyright, and then all of the copyright adjacent things that come up. A lot of times you won't know if something is copyright or is not copyright. So I can help you work that out. With OER, people tend to get kind of hung up on the licensing issue, and it is a little bit complicated. And so I'm here to help you sort of sort that out if you have any questions. And so today I'm going to go through kind of the basics, but also sort of the parts where it gets hung up. And there's been some new action in this area that I want to make you aware of, sort of a loosening up of standards so that we can actually include material that is in copyright, but that we can rely on some exceptions to copyright to take advantage of. Okay, so this presentation is going to cover some basics of copyright and some basics of open licensing. Then we're going to talk about how the licenses will affect how you can use copyrighted digital resources, which includes music, images, other people's textual material, other people's open textbooks, things like that. And then at the end, we're going to talk a little bit about what you own, what the university owns, how you figure that out, and also about something new called fair use inserts, which is a brand new concept as of February of this year. So basics of copyright. This may be knowledge that you already have, but copyright is not really an intuitive area of the law. It's a very kind of, it's grown organically, and it has a lot of really kind of strange rules and assumptions. So this is kind of what I was alluding to earlier. You don't always know when copyright is implicated. Sometimes it sneaks up on you, and you'll realize after you've already put something together that, oh my gosh, I may have a copyright problem. So I always include this slide, and it's so that you can figure out or identify when you have a copyright issue sort of early on. So copyright is implicated when you need to use someone else's stuff in your stuff. So, and not everybody's stuff is copyrightable or is protected by copyright, but a lot of it is. And so there's stuff that's protected by copyright, can be a document, somebody else's paper, article, portion of a book, a photograph, a drawing, cartoon, map, movie clip, any kind of audio recording or music, videos, things like that. And if you're using it in your work, you need to use it in your presentation, you need to use it in your OER that you're creating. You don't really have a free, just because you're creating something educational in nature doesn't mean that you kind of have a free ride. You still really need to look at the copyright in everything you're using. So do you need permission or a license? This, not always. And copyright's one of those things where it really it depends on the particular circumstances of your use, what you're using, and it changes all the time. So you're gonna have to reevaluate it every time you use something, and that sounds excessive. It's one of the beauties of open licensing is that if you're relying on a license once, you can pretty much keep relying on that open license. That's not true if you're relying on fair use or an exception to copyright. So you can look at, is it even copyrightable? There's a lot of things that aren't. Short phrases, titles, words, ideas, data itself, facts, things like that. You can always sort of extract data from a copyrightable source and reframe it or redraw it. You should also ask, does it have a license? So if I'm getting something from a website, I may need to read the terms of use of that website because that's going to control what I can use on that website. Similarly, if I'm using, say, I want to use Netflix or Spotify, you need to look at the terms of use because that license is going to control your use. And this comes up way more than you would think. Licenses control a lot of what we do now. It's pretty much everything we have comes in digital form. Usually a license is going to control that. And then fair use. So you may be able to use it under fair use. And this is true even in this space. Previously, just the last iteration of when we were developing this course, I really told people don't rely on fair use because it's difficult. Anybody who uses that OER in the future is going to have to reevaluate that fair use. But it's now becoming a thing. And we have some best practices that we can rely on now. So at the end, we're going to talk about that. So copyright this is a basic definition of copyright. It comes from the statute in the US, but it was developed over a long period of time through case law. It is an original work of authorship that has been fixed in a tangible medium. And every single one of those elements of the definition is still litigated today. So even though this is in the statute, it developed over time, it is still evolving. And I give you an example is authorship. What's authorship? In this country, authorship means that a person, a human being, has to create it. In some countries, such as Japan, authorship is defined as including AI, so computers can author works. So that's something that probably will keep evolving. Fixation is often talked about. What does it mean to be fixed? In terms of what we're usually dealing with, that means written down in print, photograph captured that way, audio, visual, media, captured in some kind of medium. So some kind of recording or some kind of manual notation. So just know that this is still sort of out there. It does need to be an original work, which means if your grandmother created it and she did not fix it, you can't take it and fix it and have a copyright in it. Because it's not original. So there's a lot that plays into this, and it doesn't come up in our work very often, but occasionally it does. So copyright has several exclusive rights. I've condensed them. This is also statutory in the United States. And by exclusive rights, that means that you can exclude others from doing this. So really, they're your exclusive rights. You own them. You can give people licenses to do them, but you can basically keep other people from doing these things. And that's the right to copy, to make a copy, to make a derivative or to modify it. So this comes up a lot if you find a PowerPoint that you like online and you want to switch it up and make it your own. You really can't do that unless you have permission or you fall under an exception or something like that. And that's a really misunderstood idea, that you can't really start with somebody else's copyrighted material and make it your copyrightable material. It really just, it doesn't work that way. The right to distribute it, so that means sharing. It means sharing online. It means sharing in an email. It means handing out to class. It means all of those things. Now, there may be some exceptions that allow you to do those things, but you have to really think about, even if something you see is shared all over the internet, so that must mean that it's free to use. Just because other people have shared it doesn't really mean that it's a good idea for you to share it. I see there's something in the chat. Is there a question?
Yes, Scott was asking, how does satire work?
Oh, okay. We'll get to satire if you don't mind putting a pin in that when we talk about fair use. Yeah, because that's like the whole idea, but I can use it to illustrate that point. And then, display. So display and perform, they're really sort of two parts of the same thing. So you display like a sculptural work, or fine art, things like that, and you perform things like music and video and things like that. And these are a little bit, they're specific to different media, and these rights are still changing, and these things tend to be sort of chopped up in different ways, so that one way it comes up in our context is streaming rights. Streaming is considered to be a performance. So you can think about it that way. Sometimes it doesn't really make a lot of sense, but the copyright law has had to evolve really sort of behind the technology, and that's going to keep happening. So is something copyrightable? I kind of covered this. Data and facts are not copyrightable. Ideas, methods, and processes, those are covered by other kinds of intellectual property. Logos, things like that can be both copyrightable and trademark. So just be aware that what you have may be protected by something else. Sometimes people want to use words and phrases and titles and things like that that are actually protected by trademark, but not copyright. Is it in the public domain? So public domain is much misunderstood. It really only covers a very small subset of things that are, say, online. But if something is in the public domain, it's not protected by copyright at all. US government works are not protected by copyright. We tend in my field to say that they're in the public domain, but technically they're just not protected by copyright. It's not true of other countries. It's not true of state and local governments. Those works are not necessarily in the public domain. But know that if you have federal government work, you can probably use it without permission. And then we also have works in this country fall into the public domain after their duration is over. The duration of copyright in this country and many other countries is very long. It's if it's by a person, a human being, then it is the life of the author plus 70 years. So it is inheritable. And then if it's a work made for hire, which means a company, a person made it working for a company, then it is 100 years from creation. So it's quite a long time. If you have things that you know are very old, then you're probably okay. Open licenses. So these are the things that are going to run our OER. So you really need sort of a working knowledge of open licenses, but they work with copyright. So you have to think of them as controlling your use, but they actually work with all of the tools and understandings of copyright. And most open licenses have some of the exceptions to copyright baked in. So for instance, fair use. If you are wanting to use something that has a Creative Commons license, but fair use may apply. Realize that even if the license may be more restrictive, that fair use is going to allow your use. And we'll get into the weeds on this because it can be kind of a puzzle in your head to work out some of this stuff. Is that chat still Scott or somebody new?
Still the same old question.
Okay, sorry. Oh yeah, because I haven't clicked it. Okay, so Creative Commons. Creative Commons was it's a nonprofit organization that was developed sort of in response to this duration extending the last time it was extended. And it's based on some open source software licenses, notably copyleft licensing. But the idea is that we have sort of a system of licensing for text, music, images, things that aren't software that we can very cheaply affix to our work and to share with others so that we don't have to go to a lawyer and write up a document. We can just put this license on there or an icon of the license, and that gives everybody else the ability to say, hey, I can use that. This person has openly licensed it. And it typically has three parts to it. So there's kind of the legal license that's behind all of it. Then there's this sort of easy to use, understandable description of the license with the icon that indicates to people that it is an open license. And then there's a machine readable component that allows these licenses to be used in search engines and in conjunction with sort of buckets of images or music. And so you'll see that Creative Commons, that machine readable component, is running behind. It's used in Google Images, Flickr, and a lot of sort of free to use third-party websites where you can go to find free to use or copyright compliant work. This is typically what one looks like, this icon. If you see this, then you know that the creator has openly licensed it and that you can use it. And the basic terms are for all the copyright, the Creative Commons licenses, are that you can use it subject to the terms of the license. They can't revoke the license. They can't change it after you use it, in other words, and you will have to attribute it. So in most cases, you're going to have to put an attribution, which just means you've got to say, hey, I'm borrowing this, and this is the title of it, if there is a title. This is the author. What's the source? So linking back to the original source, if it's a digital object that you got online. And then what was the license for this? So you can put this icon or you can note it in another way, but those are the basic things. It doesn't really have to be like a deep citation, it doesn't have to be in any particular format, but those are the things that that makes up attribution. These are all the different flavors of the licenses. They go from the most open to the most restrictive. Typically, open licenses, the most open licenses are attribution CC BY, this one right here. That lets you use something with only attribution. That's all you need. And then the next one is attribution share alike. And that means that you can use it with attribution, but if you are remixing something, so say you're making a mashup, or you're putting some music with your video, that's making a derivative. And so you would need to license that derivative that you made, that video with music. You need to license it either share alike or a more open license. This is a hang up for a lot of people because they don't want to license their work share alike. They don't want to put an open license on their work, but they want to use open licenses in their work. So that they really can't, if it's share alike. It doesn't really apply to open OER. You can use share alike licenses because you want it to be open. You're going to license it fairly open. You're going to either license it CC BY or CC BY SA. The other licenses while they're still open licenses, they're restrictive enough that we don't usually consider them to be OER. And that's because they don't work very well together. And this is the part that I've had to simplify for this, but they just aren't compatible with each other. And that can create problems with people wanting to mix your OER with another OER. It can run into sort of problems with the licenses not really working together. All right, and I can go into the weeds on that if you just want to contact me and you want to know more about it. In the future, if I have enough interest, I'll do something very specific on it. But I found that it was a little bit complicated and it was just confusing people. So what is attribution? I mentioned this a little bit. Title, author, source, and license, tassel. It's the easiest way to remember it. A lot of third-party sites where you, like, say you're getting an image from somewhere, a lot of them will have an attribution tool. So it'll already have the attribution built for you. You just click on it, that saves it into your clipboard, and then you just repaste it. Which
Stephanie?
Uh-huh.
Hey, we do have a question. Can I go ahead?
Good.
Okay, from Elliot, asks if we're creating a work in an audio format like a podcast interview, would attributing the material in the description satisfy the requirements of the license, or would it require verbally referencing it?
No, and that's a really good question. We get that a lot with, say I'm making a PowerPoint. I don't want to gum up my page with the caption. You can do it in a resources at the end. The attribution just has to be near the work. So in like a YouTube video, you could put it in the notes.
It's interesting. The other aspect to that, though, can you get away with just verbally giving attribute, or does it have to be sort of written?
Yeah, no, you could verbally. So say you're doing a podcast, you could just say, I've seen it on some podcasts where it's really kind of the same thing you do to not be accused of plagiarism. So you say, hey, I'm reading from so-and-so's book, which edition maybe would be the source. And then they've given me permission to use it, and that would be the license. Or I'm just going to use it under fair use. It's hard on podcasts. You usually see them that they either have permission or they're using a very small amount that would fall under fair use. I would caution you, though, if you're reusing music, that typically is you're going to have a license to reuse music and audio. But that's just because music is different. Music is much more monetized in very small proportions. Okay, so now we're getting to fair use inserts. This was these links here are to the actual best practices in fair use for open educational resources. And it was put together and written by people who are my colleagues in copyright, much more revered and much more expert. And they've come up with this idea that you shouldn't be restricted in creation of OER. You shouldn't have to just use openly licensed work if it's going to really hurt the quality of the work itself. So they have said that there is no reason why it cannot still be, you cannot rely on fair use in an openly licensed textbook, for example, or course. And the way that this works is they have referred to these copyrighted materials that you're bringing in as inserts, which I think is really healthy because we can call them inserts, and then that fair use inserts is something different than an openly licensed image. If I'm using a fair use insert, I know that it's protected by copyright. I don't have a license to use it, but I'm going to be relying on fair use for it. And it pretty much operates the same way. It's the really good example is, say you want to teach a poem, and you don't want to use an openly licensed poem. You want to use like a real poem. You can use that poem. You just really have to flag that it is used under fair use so that future users of this OER know that they're going to have to reassess that use and maybe be on the lookout, that just be aware that it's used under fair use and reassess whether or not it's the right amount, whether or not considering the use of the OER, whether or not that use is still fair. This really hasn't been tested because it's just been out for this year, but we found that when copyright experts put together these best practices, they do tend to hold up. They haven't been overturned by any courts. The courts kind of, we're hoping that the courts will give them deference, and that we'll be good with this. I've been sort of hesitant in the past to say, oh yeah, rely on fair use in your OER, but I think we can on the basis of this work by these people. So if you want the links, I'm going to provide this and you'll be able to go and read those. So what are inserts? So inserts are pretty much anything that you need to use for a pedagogical purpose within your OER, and they can be pretty much anything. So it's kind of like back to that slide of somebody else's stuff in my stuff. The use cases are fairly wide. I think. So you can use an insert as an object of criticism or commentary. So if you are actually going to be dissecting that poem or that artwork, you're going to be talking about it, or that movie, you can have portions of it placed in there under fair use. Also for the purposes of illustration. So say literally an illustration of a heart that you took from a textbook that is in copyright. Incorporating content as learning resource materials. This was a little bit more difficult for me to understand, but if, for instance, Bloom's taxonomy, you could take someone else's sort of illustration of Bloom's taxonomy. There's a very common one where someone has said, put out all the verbs and everything. And, you know, we don't really know who created that. A lot of times those are online. It's really hard to figure out who owns the copyright to it and how it's, you know, we don't really know much about it. You can incorporate it under fair use because it's meant for education and it's a learning resource. And then similarly, you can repurpose pedagogical content from existing educational materials. And this comes up a lot where, I mean, how it comes up for me is you have an out of print textbook and you want to rework some of the stuff in there that's maybe not in the new editions, and it's going to be difficult or impossible to get permission to use that, but it's really useful and it would serve your pedagogical purpose. You can put it in under fair use. And now we're going to talk a little bit about what fair use is, and I try to avoid fair use because it is complicated and it involves your an analysis every time you use something, and also it's very context specific. Fair use is a judicial concept that's developed over time, which means that it was at first a common law concept, and it developed because there was this idea that, you know, copyright protects some things, but they're really, the purpose of copyright is it's based in our First Amendment sort of right to free speech and right to create new things and use existing materials to create new things. And so it developed in this idea that for some things, we should be able to use them without having to ask permission or get a license. It should just be part of our experience that we could do that. And so this developed over the course of time. So it's very organic. It now has been sort of enthroned. It's a statute. It's a federal statute. And so we can depend on it. A lot of people refer to it as a right. Technically, it's an affirmative defense. So if you were ever sued for this, for infringement, you would raise it as an affirmative defense, and you would have to prove it. So, but we do consider it a privilege, an exemption, an exception. Technically, if you do have a right to fair use, you don't have to pay royalties. You don't need to ask permission. It's not infringement, and it can apply to any modality of work. So music, text, anything that could be protected by copyright. This is the sort of preamble or the beginning intro to the statute. And they specifically call out criticism, comment, news reporting, teaching, scholarship, and research. So we rely on that language a lot in this context. And oh, I see there's another. Is there another question? Sorry.
No, not at this moment.
Okay. We really do rely heavily on this because what they're saying is, hey, before you even do that complicated analysis, we want to let you know that we think these things are going to be fair use, or they're more likely going to be fair use. Doesn't mean you don't have to do the analysis, but it just means Congress thinks that if you're doing these things for these purposes, then you're headed in the right direction. Courts haven't always backed that up. So you have some squirrely stuff, but there really isn't a lot of higher ed fair use judicial notice. So we don't have a lot of cases on this. We have to sort of extrapolate from the ones that we do have. But that doesn't mean that it couldn't come up. So I try to be as close to the reading of the law as I can when I sort of do these things. So the 4 factors, you have to analyze your situation in light of the 4 factors of fair use. Not one is more dispositive. They're not equally weighted. You have to look at it, sort of the totality of it, right? So you look at the purpose and character of the use. That's what you're using it for, how you're using it. And it is written right into the statute that nonprofit educational purposes is more likely to be fair use than a commercial use. So we have that going for us. We can usually tick that box off, unless we're, of course, using it for marketing. And just because we're an educational nonprofit doesn't mean that our marketing efforts are not commercial in nature. So that's one thing I'm always like, yeah, if it's for marketing, it's probably commercial. Doesn't mean it can't be fair use, but it's commercial. And then you look at the nature of the copyrighted work. Has it ever been published before? That's the chief. This is often considered to be the least important factor, but it does come up. So if it's something that you're pulling out the most important part of something, well, that's the next factor. I'll go into that. But if it's unpublished, then it's less fair than others. So the 3rd factor, the amount and substantiality of the portion used. So in relation to the whole. So if you're using 80% of a book, that's a substantial amount of the book. It's less likely to be fair. If you're also using the very most important part of something, that's most likely not to be fair. This isn't always important, and now I'm going to answer Scott's question that, and it's not really true with satire. Satire has not been, the courts really look on satire as not, it can't be fair. And the most recent case was the Star Trek mashup with Dr. Seuss. So the court found that the sort of rewriting of the Dr. Seuss, I forget what book it was, but the Dr. Seuss retelling, talking about the Star Trek theme, that was using the Dr. Seuss material in a way that was not fair. And it's because even though it was satirical, it wasn't a true parody. And it was really just taking some copyrightable material and it wasn't deemed to be fair. So be very careful about satires. This comes up a lot with, well, we want to play the theme to The Office because we have our own sort of version of The Office, or we want to take our parody of a song and put new lyrics to it and use that. Those are really not parody, those are satires. You're using that frame of the copyrighted work to make another funny work, right? It's not considered a parody unless you are parodying the thing being copied. So if you're making fun of, or you're writing a parody version of, like Weird Al. Weird Al does parodies, right? A little known fact is that Weird Al also gets licenses and permissions. He typically doesn't do it without a license. And I don't think he ever has done it without a license. So fun fact, he doesn't even want to draw that line. The biggest example that the Supreme Court came out with was the 2 Live Crew, their version of the Roy Orbison Pretty Woman. Was like a rap version. They used a lot of the copyrightable elements, but the court said that that was a parody of the original. And so that was fair use because it was transformational. You're never going to get permission to make a true parody. So that's where we stand on that. A lot of times it's very difficult to see the difference between a parody and a satire. So just be aware. And then the most important factor is the effect of the use on the market or the potential market or the value of the copyrighted work. Courts have said this is the most important factor. And they talk about it in terms of if it's a market substitution. So if you are putting a scan of this book on your course so that your students don't have to pay for it, that's a market substitution and it's not fair. That's probably the biggest example. If instead of paying for this copy of this article, which you can license, you're putting it in your course site, that may not be fair. You probably should get a license for that. And that's something people don't really understand, but I'm always trying to get people to understand that if you can license it, you probably should license it. And then we have this checklist that was created by, I think it was Ohio State created the first one. It's been criticized, these checklists have been criticized fairly recently by the Supreme Court, not the Supreme Court, the 11th Circuit. So we use them sort of to help you gauge your analysis of what's fair. I'm working through these. It's on our LibGuide and it's linked from my info. You can use it and rely on it. It's pretty much all we have, so I pitch it. It does help you sort of establish, wait, is this fair use or not? I like to keep a record of it, so it shows I did my due diligence, but ultimately it may not be very successful. Here's a very important part of that Roy Orbison 2 Live Crew case, this idea of transformative use, that if what you're doing with the work so transforms that meaning of the work so that the meaning is ultimately changed, then that's more likely to be fair. And we see this with mostly in the context of appropriation art and collage. If you see an artist is really trying to take other people's work, maybe make a mashup or a remix, but the ultimate meaning is changed, then that's going to be fair use because it's transformative. It doesn't mean just a translation or a transformation from one media to another. And in the case of the Star Trek, Dr. Seuss, what the court said was it wasn't transformative. Ultimately, the meaning was very similar. And this has come up with, there's a Seinfeld case where someone created like a sort of a FAQ of all the things that happened in Seinfeld episodes. And the court said, well, that's so similar to, you're using the Seinfeld content and you're putting it in a different format, but it's not transformative. It's something that the creators of Seinfeld who own the copyright might do. So that's a future market. So that was not transformative. So you see this kind of still being discussed. Here's nature of the work, amount of the work, and effect on the market. So that's that section. I don't know if anybody has any questions at this point about that kind of evaluation. I'm going to sort of, it's very, very little left, and then we'll have time for questions about specific stuff. So I do want to talk about what you own and how you can retain your copyright, and then ultimately using somebody else's work, what's the best way of going about that? What do you own? So this comes up here all the time. So you own things that you create in the work that you do outside of the scope of your employment here. And that's kind of like a weird thing. I'm not going to get into the weeds on it, but copyright has a doctrine called work made for hire, which generally the default is that if you create work that's in the scope of your employment, your employer is going to own the work. So for instance, this PowerPoint is created within the scope of my employment. My work is going to own this. I'm not going to be able to take this and sell it to somebody else. I might be able to do that, but Texas State is still going to own it, and they'd just be giving me a license to use it. Now you own the copyright in your scholarly work and in the instructional materials that you make here, but that is only by virtue that Texas State is giving that to you by policy. That is not the normal default. So just know that if you worked in another industry, if you were writing code, even if you did it in your garage on the weekend, the tech company would claw that back. So there's really no way of changing this except by contract, but it does have to be a contract signed by both parties. So this is a tricky area if you are creating, say, OER. We have recently changed the copyright policy of the university to allow you to place open licenses on work that might be in the scope of your employment. So I am able now to place a CC license on this PowerPoint and share it with the world under that policy. It might be more difficult if I was going to start selling it, things like that. If anytime you're going to be making money, the university or your employer is going to try to capitalize on that. So this is an area where you see that universities are starting to make money with the distance education and online education. So I suspect there's going to be some tension here in the future. Right now, if instructional designers help you with your work and really work on developing it, then the university is usually considered to own the work and you can take a license in it. But if you're developing it without the help of the instructional designers, then you are going to own it and the university is going to take a license. Really, there's there's really not too much difference between how that actually plays out in real life, but it comes up a lot and I just wanted to put it in this presentation. What do you not own? So the rules are different for inventions and discoveries. Just know that pretty much anything, if you come up with the idea here, the university is going to own it. The data, if you're collecting data for the university is going to say that they own it. I know that that's sort of contrary to how faculty think about the data that they've gathered, but you'll see that in the next one, and that is in grants. If you're doing any kind of work under a grant, the university is typically going to own any of that work. And I will point out that even work if you make under a developmental leave, that's considered an internal grant. So be very careful if you're working under grants or on developmental leave that, and you have a work that's commercializable, the university may try to claw that back. And I have to say, I don't know if it's right or wrong. They're just saying how the law works and how the policy works. If you're asked to make something, so say you're asked to make a manual, that's considered directed work and the university would own it. We can get into the weeds about all that. We do have a copyright advisory committee that's made up of administrators and faculty from across the university, and that's their job to sort of hash that out. But I'm the chair, and so I do try to be fair about that. And then we have changed our policy in response to problems that we've seen. So we're trying to be responsive within how the law is structured. Retain your copyright. I always want to encourage people to publish open access when they can, put open licenses on your work. If you have questions about how to do that, I can help you with that. So here's just a little bit about authors' rights. I usually only bring up this slide and talk about it if we have questions, but do know that students are going to own the, students who are not employees are going to own their own work. That's even if you have assigned it. And you're going to have to actually ask their permission before you can share it. So there's going to be some changes. I want to make sure I end, but I can't end any presentation that I do right now without warning you that there are changes that are happening in copyright. One of the hugest ones is that Congress developed a copyright small claims court, which means that creators who own the copyright in their work, the main use case is going to be independent photographers, and that they're going to have an easy way at the federal level and a less expensive way of suing people for copyright infringement. So I just would warn you to be very careful about using stock photographs that you find on the internet on your outwardly facing websites. It's just, that's a risk we run. It's not up and running. It's going to start December 27th. And we have yet to see what, we don't know what's going to happen. And I will say that you, as an employee of the university, if you were working within the scope of your employment, you should be covered by the university's sovereign immunity. And we would hope that the university would defend you in that action. But that is really unclear just because of the way the Texas statutes about immunity and about subrogation work. So I'm just letting people know you don't want to have to defend a lawsuit, even in the small claims court. So don't be putting stuff on the internet that doesn't belong to you if you don't know what it is, especially photographs. There's also going to be a change with linking. Right now, there's some regulations out about a sort of European style link tax. Don't know what's going to happen with that. And also in the courts, we're seeing this sort of judicial questioning of whether or not linking is copying. So right now we can embed video and we can embed photographs within our courses and our websites, and those are technically just links. So we aren't actually copying the material and putting it on our server. This is what's known as the server test. Previously, the courts have said, the Supreme Court has said even, the server test is the law. So if it's not on your server, it's not a copy. But courts have begun to question this. And what we're seeing in Europe is this questioning of that server test rule. It may be that in the future, if you show the image or you show the video via your site, you will have to get permission or run a fair use analysis. Just something that's happening. So do I have any questions? And this is going to be about any aspect of this at all. I'm also open to answering your specific questions at any point when you're going through this or developing your courses or anything. But I just want to see if is there anything you want to ask right now?
Sorry if I missed it, Stephanie, but all of that information about whether we'll always be able to link and so on, did you say when we might know what the verdict is on that?
I would say the beginning of next year.
Okay,
So
cool.
2022, we should know how we don't even have final regulations on how the Copyright Claims Board is going to work. So we don't know about that small claims. We don't know what it's going to look like. And then the linking, those are still open regulations. They're still in the comment period, so we don't know. But I would say early next year. And I'll give updates. And if this happened, if that linking changed, it's going to be huge. So you would see it in the news, and there'd be a huge rollout of how we're going to deal with it, on the websites and in classes and things like that. So it may not change simply because enough lobbyists may come out and say this is going to be too hard.
Well, let's hope for that then.
Yeah. I know this is a lot, but when you start selecting things that you want to use, and I can help you locate these things, that's another thing. If you start selecting them, you may see something with a weird license and have a question about whether or not you can put it in your OER. And that's when you can just reach out to me and I can explain how it works. And you can use some open licenses that aren't CC BY and CC share alike. If you're just using, like, say, an image in your textbook, it doesn't have to necessarily be a compatible license. So if you're just using things for illustration, they can be in your work without having a truly compatible. It's only when you're really, really remixing and creating a new work out of two works that aren't sort of separatable concepts that you need to have that compatible license. That's a really weird abstract idea to think about if you don't have something in front of you. So I try not to go into it, but for the most part, you can find things online with open licenses now that you can use.
Stephanie, there is a question that popped up from Laura. What is the most common license, if you found, that people put on their OERs? CC BY, maybe?
CC BY. CC BY, and that's the easiest. It's compatible with everything. It's considered, Europe has been going through more, like, they're doing more development with this, but it's considered the most open, and it's actually advocated for materials that deal with like heritage sharing and things like that. So it's considered to be fully open, I guess is the way of saying it. Share alike too. Share alike, it just becomes difficult because share alike is difficult to use with some other licenses. Share alike is not compatible with the non-commercial licenses. And even though they kind of seem to do the same thing, they just don't. They are two different ways of thinking, so they don't really work together. Do note though, I mean, I have to say there's sort of drawback people don't think about, but if you are openly licensing your work, that means people can take it and use it commercially. And that freaks people out sometimes, so they don't want their work used commercially. Doesn't mean that your work isn't out there being used openly, but a textbook publisher could take it and put it in something and resell it. It's a possibility. So you do have to be open to that idea.
Just my own question, can't you license it not to be, because I know I've seen some education materials like activity pages. And I remember reading some licensing in those printed books that indicate this is for like K through 12 education and not for reproduction or commercial use outside of those environments. Is that true?
Yes, and that's really not an open license. It's not an open license. I mean, it's basically a variation on a Creative Commons no commercial use. but Creative Commons is very explicit that you cannot change the terms of their licenses. So that is a license that is somewhat open, but it's not Creative Commons license. You wouldn't be able to place the Creative Commons. It's just a restrictive license. And so you're saying, okay, you can use this, and it's an infringement to use it any other way. I wouldn't use that material in your OER because it's not open, is the way that I look at it, unless you could rely on fair use. It's kind of like we have licenses for library subscribed materials, right? We pay a lot of money and they are licensed in such a way that you may use them for your classroom use. For most of them, you can use them in class. So but we would never consider that to be open licensing. It's just that's a restriction on use, but it seems sort of open, but it's not really. It gets really crazy and fuzzy when you start putting restrictions on things. I would actually, like, I don't know if it'll ever get written, but I'm writing a paper about that. Is that what are the effects of, when does it become, it's not a contract, right? You have a restrictive license, not a contract because it's not signed by, well, at what point is it not, is that restriction unenforceable? I guess is what I'm saying.
And clear, I would imagine.
Right. You don't want to have to litigate that license. We actually have, this has come up in the terms of our theses and dissertations. They have this restriction on them that say you can't use this for commercial purposes. Some of the old ones. And I'm like, I don't, that's on there. So that's like a non-commercial license. Like, does that still have an effect? I don't know.
Stephanie, I don't see any more questions, but there were a couple of thank yous in the chats, and including mine. Thank you very much.
Thank you.
I will just reiterate that this recording will become available at a later date. We'll make that available to you all. And our next session will be Monday, December 6th, later this year at 11 a.m. as well. So we hope you join us all then.
Thank you so much. And I'm going to stop the recording now. If anybody wants to hang around and ask me a question, I'll just hang out for a bit. If not, you can just hop off. Thank you so much.